Information Sharing and the Loophole of Spying: How America and its Allies Circumvent Domestic Laws. In an era where global surveillance and intelligence gathering are crucial for national security, the lines between necessary oversight and privacy invasion have become increasingly blurred. Information sharing among allied nations, such as the United States, the United Kingdom, Canada, Australia, and New Zealand, collectively known as the Five Eyes, is touted as a vital tool for combating terrorism, cyber threats, and transnational crime. However, critics argue that this collaboration has led to a concerning trend. These countries are potentially using their partnerships to bypass domestic laws that protect citizens' privacy, effectively spying on each other's populations under the guise of international cooperation. The Five Eyes Alliance: A Historical Perspective. The Five Eyes Intelligence Alliance traces its roots back to World War II and the post-war era, where the UK-USA agreement facilitated intelligence sharing between the United States and the United Kingdom. Over time, this agreement expanded to include Canada, Australia, and New Zealand, forming a formidable network of surveillance and intelligence sharing capabilities. The collaboration among these nations has undoubtedly strengthened global security efforts, particularly in the realms of counterterrorism and cyber intelligence. However, it has also raised significant privacy and civil liberties concerns. One of the most contentious issues revolves around the practice of reciprocal spying, where one country conducts surveillance on another's citizens and then shares that information, thus circumventing domestic restrictions. Circumventing domestic laws. A legal loophole? In many democratic countries, laws restrict domestic surveillance to prevent governments from unjustly spying on their own citizens without proper cause or judicial oversight. For example, in the United States, the Fourth Amendment protects against unreasonable searches and seizures, requiring law enforcement to obtain a warrant based on probable cause. Similarly, the United Kingdom's Investigatory Powers Act mandates that surveillance must be necessary and proportionate. However, by leveraging the legal frameworks of partner nations, intelligence agencies can gather information on their own citizens without directly violating their domestic laws. For instance, the United States National Security Agency, NSA, can request that the UK's Government Communications Headquarters, GCHQ, monitor American citizens, thereby bypassing the constraints of the Fourth Amendment. The collected data can then be shared back with the NSA under the guise of international intelligence sharing. This practice creates a troubling end-run around privacy protections that citizens in democratic societies have long relied upon, says Jennifer Stisa-Granick, Surveillance and Cybersecurity Counsel at the American Civil Liberties Union, ACLU. By exploiting these loopholes, governments effectively dodge the checks and balances designed to protect civil liberties. Edward Snowden's revelations: a catalyst for concern. The practice of reciprocal spying and data sharing among the Five Eyes came under intense scrutiny following the 2013 revelations by former NSA contractor Edward Snowden. Snowden's disclosures revealed the extent of the NSA's surveillance programs, including PRISM and X-Keyscore, which involved mass data collection and monitoring of digital communications worldwide. Snowden also highlighted the extensive cooperation between the NSA and its Five Eyes partners, revealing how these agencies routinely shared data with one another. Documents released by Snowden indicated that this collaboration often included the exchange of raw data collected through mass surveillance, including data that pertained to the citizens of the partner nations. They are in bed together. They've developed their own way of interpreting the law and understanding oversight in a way that allows them to bypass the rules, Snowden remarked in a 2013 interview with The Guardian. The thin line between cooperation and overreach supporters of the Five Eyes arrangement argue that information sharing is crucial in a world where threats do not respect national borders. Cyber attacks, terrorism, and other forms of transnational crime necessitate a coordinated and collaborative response. Sharing intelligence, they argue, allows nations to pool resources, share insights, and respond more effectively to emerging threats. However, critics contend that such cooperation should not come at the expense of citizens' privacy and civil liberties. The practice of reciprocal spying essentially amounts to a form of legal jujitsu, enabling intelligence agencies to access data they would otherwise be prohibited from collecting. Civil liberties organizations such as Privacy International and the Electronic Frontier Foundation, EFF, have called for greater transparency and accountability in intelligence sharing arrangements. They argue that oversight bodies in each country should have access to information about what data is being shared, with whom, and for what purposes. When intelligence agencies share information in secret without oversight, they undermine the rule of law and the democratic principles they are supposed to protect, says Edin Omanovich, advocacy director at Privacy International. There must be a public debate about the legality, necessity, and proportionality of these surveillance activities. International agreements and domestic pushback. In response to growing public concern, some countries have taken steps to address the lack of transparency in intelligence sharing. In 2017, the European Court of Justice ruled that the UK's bulk data collection practices violated human rights laws, prompting calls for reform within the UK and across Europe. In the United States, Congress has debated various reforms to the Foreign Intelligence Surveillance Act, FISA, to prevent abuses of power. However, meaningful reform remains elusive. Intelligence agencies, by their nature, operate in secrecy, and there is often little political will to impose stringent oversight on activities deemed vital to national security. The future of intelligence sharing and privacy. As the digital age continues to evolve, so too will the methods and capabilities of surveillance. The challenge for democratic societies is to strike a balance between effective intelligence gathering and the protection of civil liberties. While the need for international cooperation in intelligence is undeniable, it should not be used as a pretext for circumventing the laws designed to safeguard the privacy and freedoms of citizens. The debate over intelligence sharing among allied nations is not merely about state security versus individual privacy. It's about maintaining trust in democratic institutions. As former U.S. Senator Frank Church once warned, if this government ever became a tyranny, the technological capacity that the intelligence community has given the government could enable it to impose total tyranny, and there would be no way to fight back. The challenge, then, is ensuring that such a dystopian future never comes to pass, by holding our governments accountable and demanding transparency in the ways they collect, share, and use our personal data.